Hi, this is your friend. I'm on your side, Dr. Cora Stack here, and I'm back to my law lectures again. Thanks very much for saying I'm as good as I mean, one of the best solicitors in Ireland, so I'd be making better solicitors than him. And another person who was head of a law firm, so she never came across anyone in law that did as much research as me. So I suppose these people, well, very complimentary of my legal abilities, given that I'm a mathematician. But I am very forensic and investigative, so I'm kind of like a journalist now. Maybe I could have done anything really, I suppose I'm so talented. You only recognise this late in life. So Stack versus the State, Ireland and others, record number 205-1412. So I'm like the journalist now who didn't turn up, but I did turn up because I was the applicant. So I'm a journalist now as well because, well, there was a bit of silence and blocking by the journalists, the media blocking. Was that trying to intimidate the judge, or was it didn't intimidate me? Because but was it intimidating the judge? And will they, if I went for president nomination again, would they block me? Would they block me again like they did the last time, allegedly, because it's all known all around Kerry. The caper there was allegedly. So was it the same elsewhere, according to my informal people that I know? Yes, it was. So applicant's written submission explained by the journalist and the applicant and the truth teller, Dr. Cora Stack. So my name is Dr. Cora Stack, and this video provides a factual overview of my written submission in Stack versus the State, Ireland and others, record number 2025-1412. I appear as a litigant, as you know, representing myself because I cannot afford legal representation of the cost of travel. And also, I wouldn't get no solicitor would take this case because, or barrister, because, of the complexity of it, and also because of the unfortunate situation with the amendment, because it involved solicitors that did this to dilute, so no solicitors like to go against other solicitors by and large. There are some, ethical solicitors, and but they're that would speak up, I suppose, but I don't know who they are. So the submission accompanies my application for leave for judicial review and for a 60-day interlocutory injunction. My request is simple: that my submission be accepted and read by the assigned judge in line with Article 40.1 of the Constitution, equality before the law, and Article 47 of the EU Charter, the right to an effective remedy. Now, I seek only that the court consider whether the state's action and omissions comply with constitutional and EU obligations. The state relies, because this is on Byrne versus Harris, where the court held that a party directive to councillors and presidential nomination was a political matter under Article 12. My case is very different. It concerns the implementation of state duties and the right of citizens to access to justice, a matter grounded in Articles 1, 6, 34, 40 and 41, as well as 12 of the Constitution and in EU law. So the constitutional legal foundations: Article 1, sovereignty belongs to the people; Article 6, all powers of government derived from the people and must be exercised. Constitution were also grounded on Article 12, but also Article 34 and 40, justice must be administered by the courts and all citizens are equal before the law. So these provisions, taken collectively together, ensure that state power remains accountable and the courts remain accessible to everyone, not just those with means. So if we look at the two cases together, State versus Stack versus the State from Byrne versus Harris, if you look at the subject, Byrne versus Harris 2025 party directive re-presidential nomination, Stack versus state duties and access to justice. Nature: in the Byrne versus Harris political question, state versus state rights-based claim. Articles Byrne versus Harris 12 only, Stack versus state exactly 1, 6, 12, 34, 40 and 41. Relief in the Byrne case was declaration, in our case was judicial review and injunction. So my case concerns public law, obligations owed to citizen, therefore it is justiciable. So I made public disclosures under the Protective Disclosures Act 2014 to 22 and EU Directive 209/1937. These instruments protect those who report wrongdoing and guarantee access to an independent and effective remedy. The refusal to process disclosures engaged. Well, it wasn't the refusal; it was the inability to process them. Because that access to the courts had been ruled out. That justiciability had been denied or cut out of the amendment, which actually breaches Articles 47 EU Charter, Articles 12 TEU, and Article 6 and 13 of each. That's extremely serious. The European Court of Human Rights held in Erie versus Ireland 1979 that access to a court must be practical and effective. That principle applies here. Equality and access to justice. As a self-represented person without resources, the current system effectively excludes me from meaningful representation. This outcome contradicts Articles 34.1, Articles 40.1 and EU Charter Article 47. Access to justice, this is my big thing. Access to justice cannot depend on income, geography, representation or connections or powerful connections. It must depend only on the right to be heard. It cannot depend on income, connections, powerful and being connected to the right people in the right circles. So compliance with EU obligations, very important. Under Article 19 TEU, national courts must guarantee effective judicial protection. The Court of Justice confirmed this in, now I'm not familiar with this case law, but it's C6416, so it seems to be a Portuguese case. Any interpretation that denies review of state conduct where rights are at stake would breach these obligations. So it's associated syndial judicial Portuguese. That's a Portuguese case law. I have to look that up for certainty in a few minutes, because my application also seeks an interim measure, a 60-day injunction to maintain stability while the court examines these legal questions. It follows the campus oil principles. A serious issue to be tried. Damages would be inadequate. The balance of inconvenience favours the status quo. So this was very important in terms of the arguments about the whole concept of the balance of convenience. How that would be, and actually the my research shows that the date in which that could be decided was exactly the 23rd, not before it or after it. This case speaks to something larger than one person. It concerns whether every citizen, represented or not, can access justice and hold public power to account. Speak truth to power. Transparency and lawful oversight strengthen, not weaken, public confidence in our legal system. Closing declaration. I, Dr. Cora Stack, declare this summary is true to the best of my knowledge and belief shared here for the purposes of public information and fair reporting. In other words, not biased reporting or in the public interest. So it's very regrettable that I have to be the investigator, the reporter, the person that's the litigant, and the law expert and everything in this case. And there's so much, bias and manipulation by all and sundry that the only straight person that can tackle all this complexity is someone of my intellect. It's shocking in the extreme, and integrity. Equality before the law is not an aspiration, it's a constitutional guarantee. So access to justice / or equality before the law, rule of law, Irish Constitution, EU Charter, ECHR, public interest, judicial review, transparency. So that's me acting not just but as a fair and accurate reporter when this is clearly not being reported, and there seems to be a media block on this. And it is certainly now from attending a reunion in the Stole, it's very clear that the whole thing in Kerry was a manipulation, because the people watching watching the presentation online said that the whole thing seemed to favour one candidate above everybody else before everybody else was heard. So this, of course, is completely unfair system, and they said they couldn't understand how one candidate was selected when everybody else's presentation was just as good, if not equally better. So these are all the issues we're raising. the unfairness of all of this. So when anyone to say that this is a fair process and it's non-justicable, I mean, I think that's a very poor judge in my opinion. But that's my own a very poor, weak judgment. But there was many parts of Mr. Justice Cregan's judgment clearly that were accurate, but this one, because he relied only on one article, perhaps he was able to bend that way. But we're it's a completely different. I mean, ours is on a completely different level altogether. But so there's no way that this can be used as a precedent in any sense in our case. But I have to put it out there because there's many journalists trying to manipulate this to try and undermine our case. And not only that, there's been undue interference with the press, in my opinion, the court press, to try and manipulate against us, which is further cause for major concern. But I don't want to go into it. I have tried to address this on X and with the journal who won't speak to me, and they won't speak to me, and they're speaking to people who are not the applicant, and the journalists aren't speaking to me, so they know I know my facts upside down, and I'd rip them apart, with the facts, and the hope against me. But that's not the point. The point is getting their facts straight and twisting them around, to manipulate against me, to try and push their agenda for whoever they want, irrespective of the rights or wrongs. That is completely unacceptable and very unfair and biased and weak journalism. But it's not so much the weak journalism, it's the agenda, pushing a certain agenda in a way, and it can be very twisted, and it kind of brainwashes people. The brainwashing, of the twisted thinking, and it's all narcissistic thinking, and all that. Unfortunately, it's everywhere. The gaslighting. So I'm not a gaslighter. I'm a street thinker. I don't know how I can do it with all the gas around me, because today I was inundated with all kinds of harassment on the email. I wonder who was doing it. It was terrible harassment, and scamming, and was somebody paid to do it? And all this, it was obviously a scam of the highest order, and who was paid to do it? So it's an awful thing to do. Pretending to be someone they were not, and it came from Galway. So was there a Galway? Element to it? A Galway, came from Galway. It certainly came to be a person who claims to be from Galway. So could there be a Galway connection to this, abuse or harassment for me? And who would I report it to? That's the question. Who would I report it to? Nobody, because there's no point in me going to the court, because they won't take statement. So we'll have to leave them out for it, and forgive them for their unfortunate situation. It's not their fault. They didn't do this problem with the major dilution of the protective disclosures there. But of course, it all followed from the unfortunate Sergeant McCabe's case. But that was only, Sergeant McCabe was only one of many. They had the Limerick whistleblowers and a pile of other whistleblowers as well. So it seems to be penalisation on me for research I did following for my academic research. I mean, it was massive penalisation and harassment and abuse. I mean, it's unbelievable what they did to me, and what they're still getting away with. And there's no sign of them now, because they know. I really feel they're only actors in the whole thing, and if we can get the case our way, maybe we can kind of find a way of understanding how much all of this shows how we need a change. So maybe just draw a line under the past and say, move forward with a new system, and a better system, as I've suggested, arbitration first, before, but always with the justicability at the end of it. So no, I completely disagree. Perhaps the justicability on Article 12 only was perhaps, you could say, arguable, subject to appeal, but on ours, with all the articles we relied on, no, I'd say subject to appeal. The other side would not win. No, I think ours is a much stronger. It is a much stronger grounds and claim. And I'm not an expert, obviously, but I've had to kind of become like a PhD in law in a very short time. So it's kind of a mathematical constitutional law. It's very mathematical, like it's very rigorous, and there wouldn't be many people as rigorous as myself able to deal with the complexities, particularly the stitch up of the what I'm saying is the stitch up of the Protective Disclosures Act to weaken it to shreds, really, based on my research, and that, this is a terrible thing to do to an academic researcher, but worse to all the people that are impacted, and all the whistleblowers or the truth tellers that will impact it if this wasn't exposed to the courts at this time, because I suppose they were hoping I'd be dead and buried in it, or I'd be so worn down by all their abuse tactics that this would never get to the court. So that's the most despicable part of it all, to be honest. Not to mind the stitch up on a number of other fronts, that they did. So I'm reserving my judgment on how to deal with all of this until I know what happens on Thursday. So I'm reserving my judgment on how to deal with all the abuse, the horrific abuse that I've been subjected to for writing research papers and trying to figure out what happened to my world-class research, and following the world-class global award I got this year. I realised that, for years, everybody was knocking me because they weren't in my league, and that's how they did it, So, well, I now have got my confidence back, but with this legal case, sure, I blew them out of the water. The other side, blew them out of the water because they were administrative, I was constitutional, and I only had a few weeks to learn the key articles, and they had, how many years did they have as senior counsel? Years and years, which was all administrative. Mine was all. It was like listening to two different cases. So they come back to me today with this thing, thinking they